Alrighty, it looks like we are live. Alright, my name is George Simons. I'm one of the founders of SoloSuit. Tonight we're going to talk about how to win your debt collection lawsuit. Looks like our audio and visual are all working okay. If they aren't, just let me know in the chat. We're going to go ahead and get going. Good to see everybody today. Hopefully we can help you out. I'm going to take like 5 minutes or so to just go over like the basics on what you need to do to win your debt lawsuit. Then most of the time we're going to reserve for Q&A. Okay, so go ahead and put your questions into the chat, and then we can help you out. Right, so go ahead and put your questions into the chat, and we will get to those questions. All right. Before we get started, I just want to note a couple things. One of those is that I'm not an attorney. I'm not your attorney. SoloSuit is not a law firm. We're not your law firm. We don't give legal advice. I note all these things just because regulations regarding the practice of law. We can't give legal advice to you, so none of this should be construed as legal advice. Right? We're just doing a little webinar. All right. Looks like we got lots of people on here, so go ahead and get your questions into the chat first before other people beat you to it. All right, we go until 1/2 the hour. I'm here in Utah. If you want, you can let me know what state you're in. Feel free to put that in the chat. We also have the great Hannah from Team SoloSuit that will be responding to chat by text as well. And then I'll do a verbal response in the video. All right. So with that, let's go ahead and get into it. Let's see here. Alrighty. All right. So first, when you have a debt lawsuit, you want to respond with an answer document. All right. First thing you get is a summons and a complaint. All right. And then you only have a short period of time to respond to that lawsuit. Right. You have like between 14 to 30 days to respond. Okay, you want to respond with an answer document. SoloSuit helps you out with that. So you can go to solosuit.com and click the respond to a debt lawsuit to get started on that. And then once you file an answer, most people want to settle. If you agree that you owe some portion of the debt in some way, settlement is for you. And you can use our product called SoloSettle to get that done. All right. And right now we have something called SoloSettle Premium is what we're calling it. Name is likely going to change. It's in beta right now. But essentially you can activate our partnering law firm to go after the collector for you and get that thing settled. So that's a big win. Honestly, I highly recommend getting on SoloSettle Premium. Just today, we've seen, as of today, we're seeing a lot of great settlements. Right? We had one person save $11,000. They got $11,000 hacked off of their debt through SoloSettle Premium. Recently, we had someone save $4,000, get that hacked off their debt. Right? In this case of $11,000, that's like over 50% of their debt was eliminated by getting it settled with SoloSettle Premium. All right, so if you want to get 50% of your debt settled or something like that, go ahead and do SoloSettle Premium. All right, not everybody gets that much hacked off, but certainly could be you. Right, so that's a great win right there that you can sign up for. You just make an offer on solosuit.com/solosettle, and then you click the link to activate the law firm. All right, so that's the basics. Before we get into it, I also want to emphasize something else, right? So let's say you don't file an answer, you skip that. What happens? I don't know if everyone fully understands the bad situation that results if you do not respond to your lawsuit. All right, so let's just lay out some of the things. So if you don't respond to your lawsuit, you will lose automatically by default judgment. All right, so that means everything in the complaint will be deemed admitted and true by the court. Okay, so that means all the money that they say you owe, you will owe that money if you don't respond. Even if you never had that credit card debt, if you don't respond, you'll now legally owe that money. Even if they never served you, you'll now legally owe that money. Even if the statute of limitations expired, you will now owe that money if you do not respond. All right, so that's something to keep in mind. So that's default, and then your wages will be garnished. All right, so the collector will come after your wages. They'll file a writ of garnishment with the court and with your employer. That means your employer will, instead of sending a check to you every month, they'll send up to 25% of that directly to the collector. You won't have an option to get out of it. You won't be able to be sneaky, get out of it. They'll send 25% directly to the collector until the total amount of the debt is paid off. All right. The other thing that can happen is liens. So if you have any property, cars or houses, they can get a lien against your property. So when you sell that property, like when you sell that house, the money from that sale will go first to the debt collector to pay off that debt. So if you sell your house for $300,000 and you have a $10,000 debt with a lien, $10,000 will go directly to the collector before it goes to you. That's what happens. All right? That's another thing. Another nasty thing is statutory interest. All right. I've been meaning to write an article on this. Don't know all the state rates offhand, but oftentimes statutory interest is around 10%. So after you get a judgment against you, they will get additional 10% interest on your debt, which will compound in addition, usually, to the loan interest in the contract. The other thing on top, like that will factor into that statutory interest, is attorney fees. Right? So a lot of states don't really regulate how much they can say you owe them in attorney fees, but usually what happens is like the plaintiff will say, okay, in your contract, if you have a credit card contract, it usually specifies this. But the plaintiff will say, okay, to collect this, I have to pay this law firm. I have to pay this law firm $1,000 to file a complaint and summons. That means I'm going to sue you for an additional $1,000 to pay for this law firm. And they can say, like, I paid the law firm whatever. Like, I think I saw one time where the people said they paid the law firm like $10,000 to file a complaint and summons. Right? And if you don't respond, nobody's going to do anything about that for you. All right? The judge isn't going to care. The court's not going to care. Plaintiff certainly isn't going to stop themselves from doing it. So they can say their attorney fees are whatever, however much they want. Of course, some states do have regulations, and it's illegal to have too many attorney fees, and sometimes. But oftentimes they can just kind of get away with this. All right, so those are a few things that will pile up and can easily make your debt double or triple or more across the lifetime of a garnishment. So if you don't want these things to happen to you, you just gotta respond by filing an answer in court. All right. Oftentimes the case will get dismissed. We recommend that the best option, best way to wrap up a case is by settlement. So you might want to get it settled as well to get it nice and tidily wrapped up. All right, but there you go. Yeah, about 20 to 30% of our cases oftentimes get dismissed. Another 30% of them are going to settlement or so. So definitely recommend responding there is hope. Have hope. Persevere. Get this done, right? This is the end of the path. You're close to getting this resolved. You just got to file a response and get it settled, and you can get back on the right track as far as your credit goes. All right, so there we go. Whatever questions you have, make sure they're in the chat. We're going to get into the questions right now. All right, Arlene, what is the next step if it's been almost 8 years since the debt? Okay, so you are asking about the statute of limitations. Sometimes we somewhat ironically abbreviate it to SOL. Let's check out our standy statute of limitations calculator from SoloSuit. Alrighty, so we got this guy, defense. Nice GIF here. Hopefully our GIFs make you laugh on our site. So depends on what state you are in, Arlene. Looks like you're saying the state is in New Jersey. So let's punch in New Jersey. Let's assume it's a credit card debt. And let's set the date back 8 years ago. Go back in time. 8 years ago was around 2015. So say January 1st, 2015. So that's the date, assuming that's the date you last made a payment. We're going to calculate that. In this case, the statute of limitations would have expired if the last date you made a payment was the 1st of January, 2015. Statute of limitations for credit card debt in New Jersey is 6 years. Statute of limitations expiration date would have been December 31st, 2020. And you can always check out the actual statute here. Just check your state's statute to be sure. Let's see if it works. It works. Look at that. The link works. Takes to our friend Case Text, which is an excellent business. And it talks about here, you can see the actual law breaking down the statute of limitations. Okay. So that's the general idea there. If it's been 8 years, and so if it's been 8 years and you're being sued for a debt, you must, and the statute of limitations has expired, you must respond to the lawsuit to assert that the statute of limitations hasn't been expired. If you do not respond, nobody will care that it has expired. Okay? Judge doesn't care. Plaintiff doesn't care. The only person that cares is you. And so you need to respond. All right? The only way the judge is going to care is if you bring it up and tell him, hey, statute of limitations has expired. That means I do not owe this debt anymore. Or they can't sue me. They can't sue me for this debt anymore is what that means. All right. Moving on. Buffalo Bob, what's up? Should I wait until I hear a response for answer to the suit before trying to submit a settlement offer? Let me read it though. I'm not sure what that meant. Should I wait until I hear a response to the answer to the suit before trying to submit a settlement offer? I think you're saying that you... I think what you're saying is that you got the summons and complaint, filed the answer. Now you're wondering if you should wait for them to respond before filing a settlement offer. It's up to you, right? I'm not your attorney, not giving you legal advice. Generally speaking, what we see works best is you file an answer, and then immediately after, you make an offer to settle. Okay, we'll get the answer filed for you, and then we'll send that settlement offer to the collector. You don't want to wait to settle until you're in hot water. Okay, if you owe the debt in some way, the case probably isn't going to get dismissed in a meaningful way. That 25% of people that get their case dismissed on SoloSuit, that's usually people who don't owe the debt. They're being sued because of like personal injury or something like that. Okay, a little while ago we had a woman who was sued for $35,000 by American Express. $35K. Imagine that, being sued by one of the biggest corporations in the world for $35,000. She came to SoloSuit, she filed an answer, case dismissed. She did a couple things, she got the case dismissed. Big win. It's because she was a victim of identity theft, right? She didn't actually owe the debt. Someone had like stolen her identity, got this big debt. Got the case dismissed though. Okay, so that is how that goes. If you actually owe a portion of the money in some way, probably your best outcome is going to be to settle. You want to try to settle as early as you can. I was just reviewing some cases on people who waited a little bit too long to try to settle. Right? You want to try to settle. You want to try to get the ball rolling early. All right. Moving on here, yoga. What's up? Hope you're doing yoga right now. Mine is not a lawsuit yet. I sent a debt validation letter a year ago and just got something back from them a year later. And now I don't know what to do. Sent a debt validation letter a year ago, just got back something from them a year later. Okay, so you aren't being sued yet. You got a debt validation letter. Okay, so how that works is before the summons and complaint roll in, what can happen is, they might send you a collection letter. And then most people will want to respond to that with a debt validation letter, what we abbreviate as a DVL. Sometimes a DVL leads to a lawsuit, summons and complaint. The debt validation letter, you want to review our articles. We have excellent articles on debt validation letters. You want to review one of our guides, maybe Hannah can put the link in the chat. I don't believe the FDCPA specifies a response date. It does say that the collector can't attempt to collect on a debt until they have validated the debt. But if you send them a debt validation letter, they don't have to respond within a certain time frame. You have to spend, unfortunately, so you'll twist the fate, you have to send a debt validation letter within 30 days of receiving their collection letter, but the law doesn't specify how long they have to respond. So if they send it back and it's like, basically the question is, do you feel like they actually validated the debt? Are they providing good evidence? Are they not? Etc. Up to you to determine what to do next. If they have like really good evidence that you owe the debt, maybe you want to attempt to pay it off. If you want to fight it, just wait, not do anything, see if they sue you and take you to court for it. At which point you can try to settle. Alrighty, moving on. Alexander, does Amex usually pursue arbitration if motion to compel arbitration is used? I don't have data on this, but generally speaking, no, right? So what he's saying, so you get a summons and complaint. A path that some of our customers go is you get a summons and complaint, you file an answer, and then after filing an answer, you might try for an MCA, and then oftentimes the people use that as leverage to settle. All right, so if you want to do an MCA, motion to compel arbitration, that's great. We partner with some law firms on around settling, and they also do motion to compel arbitration, and it works great. They see good results. We see great results as well with the motion to compel arbitration. The idea here is you're leveraging the arbitration clause in your credit card agreement against the plaintiff. Most credit card agreements specify that the plaintiff has to pay for the arbitration. Usually that's a few $1,000s. Oftentimes it's not worth it for them to pay that money, and they'll just drop it, right? So does Amex usually follow through? I don't have data on this. Generally speaking, plaintiffs don't follow through with arbitration. Filing an motion to compel arbitration doesn't mean you're automatically going to win, though. Sometimes defendants don't bring up the motion properly. They don't defend it properly. They might not show up at a hearing. They might not file a necessary memo with it. The plaintiff might contest it, etc., etc. So some things can go wrong. Doesn't mean you're automatically going to win if you file a motion to compel arbitration. But oftentimes, if you file that, oftentimes the plaintiff won't pursue arbitration because they don't want to pay for it. Logic. All right. About a week ago, I did the answer, sent it, doing the full solo with you. Is when should I do the ask to settle? A month? Okay, sounds like you're asking when you should make the offer to settle. Pretty much immediately. I would do it in the same day. Right? So you file an answer. And then I'd go over onto the other part of the site, and then I would make an offer to settle. And that works really well for people, right? Again, we have seen some great settlements, right? We saw one person just today, again, hack off over 50% of their debt, saving over $11,000 by using our solo settle tool, getting that money saved. All right, so big win if you want to save money like that. Solo settle is the way to go. Let's take a look at the site real quick here. So let's say you are on our website. You just come in here, right? To do the answer, you click reply to a debt lawsuit, and then you click get started. And then you just go through here, right? You select what state you're in. You can even file from Guam now. So if any of you guys are in Guam, you can select that. And then click continue. You come to the package selection screen. A lot of our people, very large number of our customers, go for the premium package because they want that attorney review. Also the faster filing time, right? So we file usually, if available, we e-file. Otherwise, we're sending it by 2 to 3 day priority USPS mail. Whereas with the standard, we're only sending it by 3 to 5 day mail. So premium is going faster. So that's a big win. People are oftentimes going for that, right? So if we choose that, then you just kind of go through the site. You got to make sure you have your complaint and summons with you because we need a lot of info from it. All right, you're just going to type in your name as it appears in the lawsuit. And yada yada, you kind of answer these questions. It's real simple. I'm going to make it real easy. So then once you complete the answer document, you can pay us to have an attorney review it, to file it for you. Then from there, you're going to end up on the documents page, and then you just click there's probably going to be this try solo settle card. If not, you can go up to the products and solo settle. Just click learn more, takes you to the landing page here, and then you're going to click get started on solo settle. It actually walks you through largely the same process. We actually collect some of the information again. And while I'm here, let me just show you. Right, so it's really easy to make an offer to settle. You're just going to type in the name of the lawyer suing you, the name of the law firm, we have you match that with our database, and then an email. I'm going to do what email should I, what fake email should I use as a placeholder here? All right, email@email.com, and then Smith Capital, and that's the email of the lawyers what I just entered there. I'm going to match the plaintiff in our database. That helps us keep track of things and know who we're working with. Then you enter in the lawsuit number from your complaint. Type in your actual address here. Okay, so let's okay, and then I'm just gonna type in some placeholders here. You type in your actual address. Then you select your birth date. I'm gonna say that I was born tomorrow, just for this. The collector needs this information. to verify your identity. They're required by law to have this information before they negotiate with you. That is why we provide it. That's why we ask you for it. We also need the last 4 digits of your social security number. Very important. You might say, like, do you really need that? And like, yeah, we really do. The collectors are required by the FDCPA to verify your identity. This is how they do it. Type the amount you're being sued for. Let's say I'm being sued for $4,000. Just gonna type that in. And then type the amount you'd like to offer as a settlement. Let's say I want to settle for $2,300. All right, so I'm just gonna type that in. Maybe that's like the money I have available next month to make as a lump sum payment on the debt. Right now, most debts are settling for 64% of the total balance. That's what most debts are settling for through our system right now. And then there you go. Submit your offer to the collector. It's free to make an offer. You only pay if the collector accepts. Right now, the solo settle commission is 19% of the total amount of the debt. Hopefully, we'll end up saving you much more than that, and you only pay if the case actually settles. Total savings in this case would be $940, right? So you get like 40 or 30% of the debt hacked off if the collector accepted the settlement. It's as easy as that. Then you just click submit. It goes off to the collector, and then hopefully you win big. All right, so that's the general idea on how solo settle works. All right. And then if you want to upgrade solo, if you want to activate, is what we call it, because it's actually the same price. If you want to activate solo settle premium, you just click a link on like the next page and do that up. Casey, I filed with solo suit in May 2022. I just got a letter telling me I have a court date in October. I asked for proof the debt was mine. This is the first I've heard back from them. This is the first I've heard back from them. Okay, so you just heard back from them. Recently, May 2022 was more than a year ago. Yeah, unfortunately, kind of like with the DVL, there isn't hard deadlines on like when the plaintiff has to respond in court. Right, so yeah, you do the summons and complaint. They do the summons and complaint, and you have like up to a month to respond with an answer. And then what happens after the answer? You know, I mean, it's kind of like a ... Like what happens next? I don't know. The collector can take forever to respond oftentimes. And sometimes they wait a long time hoping that you'll move and they'll be able to send like the documents to your old address, and then you won't find out that the case is going, then you lose the case. Something that they do. That's one of the reasons why we recommend settlement, so you can just get things wrapped up nice and tidy, so they can't really come after you outside or inside of court anymore after settlement. But yeah, with the court date, you can try out Solo Settle Premium. We can help you out with that on Solo Settle Premium. You want to sign up early before the court date is close. And then, if not, if you want to do it on your own, just want to make sure you show up at the court date, watch our videos on how to prepare for court. All right, moving on. We're just about at time, so I'm going to try to go rapid fire here. Arlene, not sure. I don't remember. Okay, that's not a question. Reina. Is it too late to ask to verify debt once I receive the summons letter? I truly do not believe the debt is mine. Not exactly. So you can't do a debt validation letter, but you can request they prove you owe the debt in the answer document, right? You just basically click the box on our website saying you want them to provide an accounting of the debt. And you want to say that, you know, you don't know if the debt's yours. Okay, Josh, I'm being threatened by our landlord for charges that are not legit per our contract and multiple conversations had with the landlord, but have not yet been sent to collections that I'm aware of. Is there anything I can do to ensure that we are contacted appropriately by the debt collection company so we can respond timely? Not so much. It's honestly a mess. I mean, you can hope that they contact you. You can tell the landlord, like, hey, before you send this to collections, just contact me directly. I can work with you. There isn't like a registry of like who owns your debt or something like that. You can try getting a credit report and seeing if there's an up-to-date ownership listed on the debt, right? So if there's a debt, it's supposed to be reported on your credit report, and then the owner of that debt is supposed to be reported as well. That doesn't always happen. Yeah. Okay, moving on. Rapid fire here. Let's see. Should we reach out via phone to collectors since they never received the certification letter? Yeah, you can try. You can try calling the collector. A lot of these collection agencies are set up to receive phone calls. We find oftentimes people have better experience negotiating over email, but the collectors do prefer phone calls, but that does kind of allow them to take advantage of you. You should check out our blog article on what states require you to ask permission to record a phone call. Most states actually don't require permission from both parties to record a phone call. Oftentimes you can just record a phone call with your own permission. Like you just opt in and say, I'm going to record this. You don't have to tell the other party. So you want to record the phone call if you do contact the debt by phone. Kristen contacted Midland Credit Management to find out if I can settle the debt, and they said that my account is on hold while it goes through a dispute with SoloSuit. Yeah, that's the thing that happens sometimes, right? It's not because of SoloSuit. It's just because you are in litigation, and they're like trying to see how things shake out. That doesn't happen very often. If you contact the Midland Credit Management directly, you want to make sure that you contact the law firm. Right. So in litigation, the debt is settled with the law firm, not with the plaintiff. What if we did file an answer, but due to being served indirectly in short notice by an acquaintance, we couldn't attend the hearing? What should our next steps be? If you lost by default judgment, you file a motion to set aside judgment, and then refile the answer. Well, why is it so difficult to get a hold of you guys? With SoloSuit, usually in my experience, it's not hard to get a hold of us. Our support people have a record of responding on average in 2 to 3 hours is usually what it takes for us to respond. You can try the chat on our website between hours of like 9 a.m. to 2 p.m. Mountain time. Usually we'll respond to chat. Yeah, most emails we respond to in 2 to 3 hours. Just email us again if something maybe fell through the cracks. But we definitely want to be responsive as we can. We want to help you out. We want to make sure that you win your case. Right. I got time for one more question. Let's see. Looks like that was actually the last question. Looks like there's a lot of chat going on. Last question I see in the chat at the moment. All right. Well, good to see everybody. If you haven't already, just make sure you go over to SoloSuit, reply to a lawsuit, and then settle. Walk through the process on SoloSettle. Very important. Get that settlement done. Do not wait. I want to get this done ASAP. Don't have things lingering over your head. All right, and get that thing settled. Good to see everybody. We are sincerely rooting for you. We don't guarantee case outcomes, can't make magic happen, but we do want you to win your lawsuit. All right, and we're here for you, sharing